Hey guys, the weekend is finally here, so it's time for a big mashup. And this one here, I've got some of my favorite judges being absolute savages. I really hope you enjoy it, and I hope you have an absolutely fantastic weekend. And we'll catch you all very, very, very soon.
So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes.
Guys, I had to share this video with you. I actually have it in a compilation too, but I liked it that much that I wanted to share it separately. I couldn't believe how awesome this judge was. She handles this sovereign citizen in such an ice cold way, so sarcastic, but not in a way that's even irritating. I think you guys will really, really like this one. I'm sure some of you have already seen it. Today was my first time seeing it, and I just love how she deals with this guy. Check it out. Let me know what you think. It's the pauses, man. It's the yes.
Yes. Good morning. 14B District Court is now in session. This is Magistrate Hillary Braley presiding. Okay, and I need you unmuted at the jail. There we go. Can I have your name, please?
For the record, my name is Thomas Stiver II. I'm the natural person. I'm the living man. How we doing today, Miss Braley?
We are upright, if nothing else.
Great.
So, okay. And you said your name is Thomas Styron.
The second.
The second.
And then I'm the natural person, the living man.
Okay, thank you for your patience there. We had a little bit of a kerfuffle. So,
No problem.
recalling case number 19S00472, that is the state of Michigan versus Thomas Ulrich Styron, the second, you said, and also calling 24W001025, that is the township of Ypsilanti, also versus Thomas Ulrich Styron. So state your name for the record.
So, for the record, my name is Thomas Styron II. Is not the name you have attached to this case is not me. I believe that's a state created entity, Your Honor. And I'm not, me being a living person. I don't. My name is in proper punctuation. I don't have a all caps name nor.
Okay, I'm going to cut you off right there. Okay.
I don't have no. Sorry, I don't have no contracts with the state of Michigan at all. Period. And so I was wondering about personal jurisdiction, subject matter jurisdiction in regards to this.
Okay, and you can continue to wonder about those at the moment. What I am doing, you have a show cause hearing on the matter ending in 472, which is the retail fraud charge. I'm showing a balance of $210 on that. And then what you're being arraigned on, that is what I am here to explain the charge against you, is a citation issued on April 2nd, 2024 at 9:24 in the evening. That charges that you operated a motor vehicle on North Ford Boulevard at or near Russell Street with no license on your person. Do you comprehend the charge against you?
I do not. I don't even own a license. I canceled my license years ago.
Okay. So, what you are being charged with is operating a motor vehicle without having a license on your person. So, I'm not asking if you agree with this. I'm not asking if you have a license. I'm asking if you understand the words coming out of my mouth as far as what this charge is.
The charge is accused me of not having a driver's license on my person, correct?
Correct.
Well, from my understanding, I need a driver's license if I'm in commerce. I was traveling home.
Okay.
I wasn't doing business at all. And also from my understanding, I don't need a license to do that.
And your overstanding is incorrect, sir. But we are not going to get into that for now. You are saying that you have understood the words as far as not having a license on your person. It is a misdemeanor charge with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both.
So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes.
So
At this time, the court is going to set a pre-trial date for you. That will be before Judge Washington.
ma'am, can we prove the jurisdiction first before we go ahead with setting a trial for that entity or a pre-trial for that entity? Yeah.
I hear you. And at this point, you are appearing in front of the court. You have put your name on the record. And yes, we are setting a pre-trial date for you.
I did put my name on the record, and my name that I put on the record is not the same name that you have attached to that case.
And you can provide documentation of such at your pre-trial date, which is going to be June 26th.
So the documentation that I have published, recorded the documentation I have published and recorded on the record, on the state of Michigan record, that says what I just told you, that I'm not who you have, that I'm not the name you have attached to that case, that's I need to bring that with me, is what you're saying? It being already recorded and on the state of Michigan records. Is that good enough?
Whatever documentation you have,
Mhm.
bring it with you to your pre-trial date. That is what I am telling you, yes. So. And again, that court date, June 26th? Okay, will be June 26th at 9 a.m. before Judge Washington. The court will enter that you are standing mute to all charges at this time.
So we're just assuming jurisdiction, though, correct?
Yes.
From my understanding, that has to be proved before we even proceed with anything else. Am I wrong?
You are not correct. The court will also set a personal recognizance bond in this matter. Basically, you are promising to show up for that June 24th court date at 9 a.m. over Zoom before Judge Washington, where you will have your pretrial. Okay, so at this point, your hearings are concluded. You are free to stand up and tell the jail that you are finished.
This is ridiculous. It is simply what your argument is ridiculous. We can go round and round in circles. Motion denied.
Hey guys, I'm working from home today, so that's why I'm not on camera. I'm probably going to set up a camera here as well so that I can go between here and the office. But anyway, I was having a look there at Judge Simpson's court, and I just came across this one. And honestly, I think my mind is as baffled as the judge's as to what this lawyer's argument actually is. This lady was told to pay her rent on time, and the argument is she did pay on time, she just didn't pay the full amount, and for some reason thinks that she shouldn't have to. And all of this is being argued over like $70-something. So check this one out. Let me know what you think. My mind is baffled with it. I don't get it. I don't get why you can't just pay it. She literally has the money, but the argument is still there, and the judge does not seem too happy with this lawyer. So check this out. Let me know what you think.
She can have a seat there. All right. This is your motion.
Your Honor, we request per COD that Ms. Payne be granted an additional 30 days to move. As per the terms of the COD, her condition was to show that she had been looking for new housing. I provided a letter from Ms. Little from Housing Europe Senior showing the properties that she's applied to. Since that letter, she's even applied to even more. She's been accepted at about 3 of them, but she hasn't had her interview yet. And then even after she has her interview, there's no guarantee that the apartment will be ready in a certain time. And I also found it was
So when are her interviews?
would you mind if little thumbs up?
Yeah. That's fine.
Take the name of the record.
Okay.
So yeah, so Ms. King has been selected for 3 apartments. And one specifically, she's in the process of an interview. We don't have a date yet because there's still some pending paperwork. It's a really long process to get all of this done in such a short time frame, honestly, to get everything done. And so I would think the interview would be next week or so. She just needs to get down there and get it scheduled. I mean, the apartment that, have the biggest lead on isn't one we really want her to go to, because obviously in this short time frame, she's not going to get a great option to move into. So it'd be nice if we got her from the others, but we'll probably have to.
Okay. All right. Thank you. Response.
We're asking, for a written for the additional order of dismissal to be enforced. Part of the additional dismissal order was that she paid rent, she paid full rent, she paid time rent. And we've informed her, as you see in the answer, of she recertified, her rental increase went up to $270 a month, and she's still been paying $247. So she owes currently $79. And she was supposed to pay on time, full amount of rent. Stated in the initial dismissal, she has not. She's been informed that she had been paid by a letter that had been paying less both times, and she has not submitted any extra money.
Okay.
Yeah.
Your Honor, the letter that plaintiff added, submitted with their answer is not the letter that they seem to have removed all of the hat payments and Ms. King's credit, and produced this ledger that they claim is what she has paid. However, I've asked on more than one occasion for a complete ledger. This ledger starts in April of 2020. Ms. King has lived at Town Center for at least 8 years, and she's been in this new apartment for.
When was she recertified?
She was recertified.
I think it's in April or March.
It was January 16th, 2025.
January of this year.
Yes. The effective date was March 1st, 2025.
Of the rent. So it's March and April. That
And
Your Honor, as part of the terms of the consent order for conditional dismissal, we were to wipe her ledger as
I recall.
did that. So before that date, shouldn't be in controversy here.
Well, that's what I was curious about.
Your Honor, the reason it's in controversy is because they wiped her account and included her February's payment, supposed to be February 7th, and they wiped her credit. Now, what my understanding of wiping her account was to remove the charges that she had since.
She was to zero out, that's what was supposed to happen.
Okay. So she gets zeroed out the credit that she has and the payment that she made for February? Because if you look back to prior to them filing this case, she had been paying $200.
I'm not relitigating the case.
Okay. Well, Your Honor, the COD says that she abide by the terms of the lease. This is subsidized housing. Paying rent late, which she didn't do because she paid on the 5th, and they didn't process it until the 6th. And not paying the full amount of rent is not a eviction cause for subsidized housing. They are required to offer payment arrangements. The goal is for subsidized housing.
She entered into a COD that she was going to pay her rent timely.
No, COD says she would not violate her lease. This is not a non-payment of rent case. Never has been.
Does she have the 79?
Yes, Your Honor, she has $79.
Then why are we arguing? Why doesn't she pay it?
Because she has credit on her account, Your Honor. It's not fair for them to keep the credit, and they reverse the half payment at a different
All right.
time. And
This
it's not a violation of the lease.
ridiculous.
Exactly.
No, it is simply what your argument is ridiculous.
Okay.
Because what I'm going to do is she was to abide by the terms. She has to pay her rent on time, got her account zeroed out, gave time for her to find new housing, gave an opportunity to then come before the court and ask for additional time if she showed that she was doing that and complying with the COD. She's not in compliance with the COD. I'm going to deny the motion to extend the time.
Your Honor, how is she not in compliance with the COD? It doesn't specifically say that she has to pay her rent one time.
It
or the
does.
full amount. It does.
It does.
It has things for late payments. It has other things that if you go to paragraph 23 or whatever, it lists the things that you can terminate. Do you have?
I'm sorry. Your Honor,
Yes.
the second line from the last line says defendant will pay March and April rent at normal time. Your signature is right here.
And she paid on the 5th.
She did not pay her full rent, ma'am.
Okay, but she paid on the 5th.
She didn't pay her full rent. We can go round and round in circles. Motion denied. Motion denied. I'm not going around and round in circles on this.
So you're in a little bit of risk.
Thank you.
Thank you, Your Honor.
Well, there we have it, guys. I haven't watched it there now. Again, this is actually the third time now I've watched it. I still don't understand the point of the argument. Okay, maybe the thing says that she has to pay on time, but doesn't specify that she has to pay the exact correct amount of rent. But I think that's kind of a given, is it not? That when they say you need to pay the rent by a certain time, that means you need to pay the entirety of the rent at that time. If that was the case, I could just pay $5 and not pay the rest of my rent and argue that, well, I did pay the rent, just not all of it. But anyway, let me know what you think. I'm going to catch you in the next one. Sláinte.
What'd you say? Ma'am, you better bring her back here. Bring her back here, Alan.
Hello, everybody. A very, very happy Easter to you all. We're back here in Judge Simpson's court. We have this... This lady decides to just turn and burn. She's just like, you know what? Screw you people. I'm going home. And she takes off, and the judge sends out the security after her. She wants nothing to do with that court at that time. Throws an absolute hissy. It seems like she's actually straight up lying in court about this paperwork or presenting fake paperwork. And at one point, the judge actually calls her out, and that is like, I'm saying it right now. I think that you just gave us fake paperwork, and he dismisses it. She storms out. Security gets sent after her, and it's a bit of a fluster clock, as they say. Anyway, I hope you enjoyed the video. If you do, make sure and hit that like button. Leave a comment down below. Let me know what you think about this whole situation, and we'll catch up with you here towards the end of it. Thank you so much. Enjoy.
Carla Green versus Dustin Mickles. Yes, there's Carla Green, Dustin Mickles, and Antoinette. State your names.
Carla Green, Antoinette.
Dustin. All right. Where are we on this, folks? Because,
I filed the proper paperwork.
well, I don't know that you did. Okay, so here's the problem. I don't think that I have subject matter jurisdiction over the case, and let me just explain it so everybody knows what I'm talking about. In order for the court to obtain subject matter jurisdiction over the case, I have to have a proper notice to quit. When we were here, and I kind of explained it the last time that we were here. When we were here the last time, you were indicating to me that you gave them a notice to quit on the case. I didn't have it in my file. And I kept asking you, well, when did you serve it on them? Because I think they were saying they hadn't gotten a notice to quit. So I said that I had to have the one that has the proof of service on it. And I adjourned it out to give you an opportunity to correct that. Because if it had been served, it was. So you filed with the court a notice to quit. And importantly, on the notice to quit that you filed, it says that they had to move by February 28th, 2025. And that you served it on them March, as I'm looking at it here, March 10th, 2025 is what it looks like to me. And it says it's served by first class mail. Assuming this document to be true, I don't have jurisdiction over the case. And in fact, I'll just say this, this document, if that's the March 10th date, it can't be, because you can't tell someone they have to move by the 28th of February and not give them notice that they have to move until March 10th. The only way that this notice, as it is signed by you, can make sense is if it were served on them on March 10th, they would have until April 11th or April 10th in which to move. So when I look at the face of the documents, this notice is invalid. With the dates that are on here, it can't be true.
Additionally, went with that notice to quit, had this file, had the police officer do it the correct way, because that's what I was told to do from this court. The notice to quit. You said that I had to show proper paperwork of me serving them the correct way. So the first time I served them was
And we went through this the last time. You gave me, and when you were talking about the police officer serving, that's the service of the summons and complaint. That I don't necessarily, as I'm looking at it, have a problem with, that they would have received a summons and complaint from the court. They would have had an officer or somebody show up to serve that. That I'm not having the issue with, and that's what I was trying to explain at the last hearing. Because the document you handed me, that you were talking about that. What I told you was the notice to quit. I didn't have a copy of when it was served on them. Gave you the opportunity, you said you did, I gave you the opportunity to correct it. I'm not sure what date it was received, but the document that we received that was received by the court is a notice to quit to recover possession of the property. I will say two things about that. First of all, it doesn't match, the top portion of that notice to quit does not match what I have in the file, which leads me to believe that it's not the document that was served on them if it was served. Then even aside from all of that, and so in reality, it's not a valid notice to quit. But even aside from all of that, if I were to say, I'll give you the benefit of the doubt, I'll just look at it, I'll take the dates. You can't give somebody a 30-day notice, tell them to move by February 28th, and not tell them until March 10th.
Your Honor, I think it's a misunderstanding. I served them a notice to quit on February 28th because I'm following all the court steps. She said, first of all, you have to file a notice to quit yourself. And then if they don't move, you come to court, you file this paperwork, and then you come to court. So I served them, correct?
No, you don't get the question. What are you saying? You have to give me a proper service here. And I don't have it. I don't know what that notice to quit. You keep saying that you gave them one. I don't know what it says. Because your two notices to quit are different. The one that you gave me just recently is different than what was attached. The top portion is different than what was attached to the complaint that was filed. One is typed, the other is handwritten. It says moved by the 28th, but the way it works on a 30-day, I tell you, if I were to give somebody right now a 30-day notice today, the 18th, I would say if I serve it on somebody today,
Your Honor, I served it on January.
just don't interrupt me. April 18th, I would give them until May 18th to move.
Correct.
Your notice, on the other hand, says you have to move by February 28th, but I don't tell you that until March 10th.
That's the second.
Can't work that
That's
way.
the second notice, Your Honor. The first notice, they told me to serve it. You have to have a 30-day notice to quit. I served them the 30-day notice to quit January the 28th. So they had till February the 28th to move.
Then why don't I have a proof of service that it was given to them on January 28th? I don't have that. I told you to come back, and usually I wouldn't do it. Usually I would have kicked this case the last time. You kept telling me that you had it. I see a notice. I don't have the proof of service on the notice to quit. I gave you an opportunity to correct. What I got
Your Honor, what
is an impossibility.
Your Honor, what you got is what the court told me to do. They said file a 30-day.
You're not going to blame the court. The court didn't tell you to do this, because I think this is a falsified document if you want to really get down to it. Because the notice to quit that I have in the file is typed. The notice to quit that you gave me is handwritten. It can't be the same. I don't want to accuse you of providing false documents to the court, but that's certainly what it looks like. And secondly, the date, as I indicated, and I will say, you can smile at me all you want, but I'm going to tell you right now, if I think you filed a false document, you're going to get a show cause, and you're not going to like what happens. Am I clear? The document that you gave me is a factual impossibility. You cannot tell somebody to move February 28th and serve them on March 10th. It can't happen that way, because you're telling them to move after the time that you told them to move. You can't do it. That's what's in this file. So giving you an opportunity to do that, I've given you an opportunity to correct it. You failed to correct it. I will state on the record, I think you provided to the court a false document. This court lacks subject matter jurisdiction pursuant to the cases decided by Michigan Supreme Court. I don't have jurisdiction over this case. The only thing that I can do is dismiss it. This case is dismissed for lack of subject matter jurisdiction. Thank you. What'd you say? Ma'am, you better bring her back here. Bring her back here, Alan.
Your Honor,
Yeah, go back there someplace, because when she comes back in here, it is gonna be a mess.
okay.
Don't go out into the hall yet. Call security down. I don't know, someone say who wants to go next. But they're coming down. I'll wait for her to come back here. Everybody doesn't have to wait for her. Jeff Lewis versus Michelle Kresnik.
Good afternoon, Your Honor.
Good afternoon.
The thing is, that she's so far in the hole now. She never paid her security deposit. She's $5,300 in the hole, and then come May 1st, she'll be over $7,500 in the hole, and she hasn't paid rent since the 1st of February.
What happened?
Pardon me?
Hang on a second. My person back? Okay. That matter is dismissed on plaintiff's motion without prejudice.
Sorry to interrupt. Your Honor, are we allowed to leave you?
I'm not clear what's going on out there.
Okay.
All right, so if you just sit tight, he was trying to explain something to me. I was trying to finish up that case and do we know?
We do not, sorry. Would you like me to?
Well, no, because I don't know what's going on out there. All right, you two, since you're the one that caused my troubles. No, I'm kidding. You two sit right there until we tell you to leave. All right? So that'd be simple. The rest of the people here are probably for my next block, which I'm just gonna let you know right now is gonna be a bit delayed, but I will get it called. And I'm gonna step off the bench and try to figure out exactly what's going on. Okay? Thank you, folks. Court's gonna stand in recess. You may be seated. Okay, you two. She's out of the building and clear. You can go. All right?
Thank you.
Just give us a heads up when you're gonna grace my doorstep again, all right? You guys take care. Have a great weekend.
Well, there we have it. Skip forward obviously through that whole part there where they were trying to locate this lovely lassie. And yeah, it seems like they either weren't able to find her, which I can't understand because, you know, Mr. Allen was right behind her and he seems slightly fitter than her. No disrespect to that lady, but he's very fit. And I don't know what happened. So obviously Judge took a bit of a recess to go and deal with that matter to figure out what was going on. Now, did he have a word with her in private? Did he maybe convey a message to her through the security? I don't know. You know, it's not the biggest deal in the world what happened. It's disrespectful and has to be dealt with. I just would have loved if it happened in open court so that we could all enjoy watching it. But evidently it's been dealt with anyway. But lads and lassies, thank you so much for joining me. Again, I really do hope you enjoyed the video. If you did, hit the thumbs up button, subscribe, and make sure and hit the notification bell because I know a lot of you guys have not been getting notifications about new videos coming up and all that kind of stuff. If you want to support the channel, all the links are down below. I'm going to have really big news. There's huge changes coming. Something big is going on here in the background at the moment. Not this background. Fuck all happening back there at the moment. But I've got some big things coming. Really big things coming. Getting a lot of awesome help. So you're going to see a big change. Covering the same kind of content, obviously, and all that kind of thing. But in terms of production quality and things like that, things are going to get a lot better. Anyway, folks, thank you again. And we'll catch you in the next one. A very happy, healthy, soft, wonderful, warm, delicious Easter to you all. Sancha.
We all brought a copy up to you. I'm not going to argue with you.
Well, you better not.
We'll just take it up later.
Miss Gillette, who is the judge here?
We already did Sanchez. We have a Tiana Richardson and a Dustin Newport I still have.
Well, hold on. That's not what I'm showing. What do you have, Missy?
I have Alfonso Caldwell and Tiana Richardson. That Newport bonded out, or no, well, he bonded on ours and then Lyon County come and got him before.
I noticed, okay, he was taken off the docket. And what did I do? Mix up Tanya Richardson and Sanchez?
Mm-hmm.
And no one mentioned that I was using the wrong name?
You were using the right name. Mm-hmm.
Oh, okay. Okay, well, and these are my couple that I don't have anything filed to show that they have to be in court. I don't have a summons. I don't have a uniform notice to appear issued by the officer in the ticket.
Judge, the girls filed the ticket earlier today.
Okay, let me see if it's, maybe I just need to double check. Mr. Caldwell.
Tickets were issued January 23rd, 25 at 20:59 hours. But
Okay,
today,
well, let me make sure they made it to the file because I'm not seeing that. I don't see that, Miss Gillette, and until I have filed verification that they had noticed this hearing. I'm not finding that. You're sure they filed them?
Arlene was the one who did it for us.
No, Missy, do you have that where you can look at it? Because I am not seeing it filed. Maybe I need to. No, I think I've already refreshed to see if they've been added. You want to
They're
check?
not in the case yet.
What was that, Missy?
I said they're not showing up in the case yet.
I don't know if upstairs hasn't approved them or what's going on.
I can check.
Would you check? We'll take just a real quick recess because I don't have anything in the file to show they have notice of the hearing, so I can't take any action for their failure to appear without it.
Arlene's gonna bring the unfiled copy upstairs, Your Honor, but they were submitted this morning by Jessica.
They haven't made it into the file for some reason. Well, I need the originals. You're thinking the originals are on file somewhere or waiting to be filed? See what Missy finds. Maybe they'll find the originals at the clerk's.
What, Judge? I'm sorry, I'm back now.
Well, she said they'll bring up, if I understood Miss Gillette right, they're bringing up copies, but where are the originals?
I think I actually have a copy because I was asking them today about it, so
Well,
I can print you off the copies that I got sent.
copies, I need original documentation that these people had notice of this hearing, either in the form of a returned summons or a citation. And I don't have one of anything to show that they know about this hearing today.
Your Honor, the citations, we get a Xerox of them. We don't get the originals. The originals normally stay either in the file with the sheriff's office now, or they go straight upstairs. But this had to be long formed because it's marijuana. And so
Well, even with the long form, I would accept, you don't have the originals, Arlene? You have copies? Have those been filed with the clerk?
Yes.
They have been filed. They didn't make it into their file. Do you know why? I don't have them in the file.
Well, because that's the clerks.
Okay. Well, Missy, did you check with the clerks?
Yes, I just checked with them and they do not have them. They're not in the queue to approve.
I know they're not in the queue. I looked through the queue. Oh, unless you mean their queue.
Yeah,
Well, what I'm going to do, now I'm looking at copies of tickets. And I've seen enough tickets over the years to know these are tickets and they are They do appear to be signed by the signature I know as Blake Fisher's, although I'm not an expert in handwriting. But I am not comfortable issuing any kind of failure to appear warrants if there's no documentation in the file. These are just hand copied to, or handed to me, but once they are filed, then I would not hesitate to issue warrants for their failures to appear. So I'm going to set these two cases over till next Tuesday. By then, I'm sure that we'll figure out why those haven't been filed. And then if they're not here at that date and time, we'll issue warrants. But they'll have to be given notice of the new date and time. And it looks like they're out of Wichita, Kansas. Yes, so.
If I have to issue new summonses, then it's going to be more than a week because I have to issue them, send them to Wichita, and have them served on them. They have their notices to appear, complaints.
All right, I'll tell you what, I don't.
I don't even get the original anymore.
Just file the copies, whatever, but they have to be filed, Ms. Gillette. I have nothing that gives me legal authority to issue failure to appear warrants. I have in the file, and I'm looking at it, a complaint, a probable cause affidavit, a notice that you're going to rely on KBI reports, and that's it. There is nothing in the file to show legally that they have notice of this hearing. So I don't know where the tickets are. I don't know why they're not filed. I understand that someone in your office said they gave them to the clerk. I understand the clerk to say they don't have them. I don't know where they are, but I do not have them, so I cannot issue any kind of warrant for failure to appear. So in fact, if you find them and get them in there even today, we can deal with it today rather than trying to issue summonses. Get me something I can legally use. Otherwise,
I'll call Sheriff Samuels and ask him if he can bring the originals out of his file.
I'm not telling you you have to do the originals. I'm just telling you, Miss Gillette, I cannot legally issue a warrant. And you know that. You know I have to have verification before I issue a warrant.
And we emailed them to your staff who has them this morning. They were sent to
my secretary is not the clerk of the district court. My secretary is not the custodian for that. They have to be filed.
Up to you. I'm not going to argue with you.
Well, you better not.
We'll just take it up later.
Miss Gillette, who is the judge here? I am not going to accept your behavior. You're putting me in a position where I'm going to have to find you in contempt of court if you're going to act like this.
I don't have the original, Judge. I can't get it to you. We filed them this morning. That's all I can tell you.
Ms. Gillette, you are not listening to me. And you're being contemptuous.
The state has contempt immunity. We already briefed this. If you would like us to get them filed again, we will file.
You have contempt immunity? Do you have ethical immunity that you can talk to a judge any way you want and have no repercussions? Is this what you're saying?
Judge, I will find the originals, whoever has them, and we'll see if we can get them to you. We will get them filed.
And we will finish this later, Ms. Gillette. At this time, Missy, it looks like Ms. Gillette has decided to remove herself from the hearing. As I said, this matter is not over and it will not be tolerated. But for now, we will be in recess.
What did you just do? Hey, come here! Stop with you! Constantly being in this courtroom.
You're not talking to your child while this case is pending.
Get him out of here.
Yeah, get me out of here.
All right, man. Right this
Back
way,
to
man.
jail.
The public trust
That's
and
enough.
the grantor. I'm the beneficiary and
he
executive.
entail
You
for?
are the trustee. There's only one position left.
Go ahead and take him out.
Any adherence and y'all keep pushing
You're
the
gonna
date back.
have
I'm ready
your-
to see. I'm ready to see my
Mr.
kids.
Fowler, this is not an argument.
You agree you violated the terms and conditions of your probation by having technical violations of your probation? I'll find there's a basis for the admission. I'm gonna find. What did you just do? Hey, come here.
Sir, come back in here. Come back in here.
You come up, sit and have a seat. You come up here. Now, have him sit right. Have a seat, Mr. Cantrell. Stand up. Stand up. Stand up. What is your name?
Mark Elkin.
What are you doing in this courtroom?
I was here seeing somebody going to court.
You just, when you left the room, you shot a bird and then said the F word when you walked out.
Not a,
Yes, you did.
not a you.
I don't care who it was at.
Okay.
Now, that is a direct criminal contempt of court. Punishment up to 6 months in the county jail. Do you have any thing to say
I apologize.
before I
to the
go
court.
forward with this?
I apologize to the court, sir.
Do you understand how serious this is?
Yes, it's emotional right now
I
too.
can complete this hearing right now, have you put in jail, and you won't see the light for 6 months. Now, this very seldom happens in my courtroom. This is serious. I don't care who you were shooting the bird at. If it was me, I'd just assume it'd be at me and somebody else. My feelings are hard to hurt. That's not the first time the bird's been shot at me.
I apologize for disrupting your court, sir. That's all I can say.
What I
Emotional
suggest
right
you
now.
do is get out of this courtroom, get out of this courthouse.
Yeah.
Go. Mr. Cantrell, come on up and let's finish this.
But I also see she's got no, other than a license case, she's got no criminal history whatsoever.
I would ask for a personal bond in this matter, Your Honor.
Ma'am, I'm going to give you a personal bond because of your lack of criminal history. I don't see any other charges against you, but there are going to be some conditions of that bond, okay? You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. Okay. You're not to have any contact.
What do you mean I can't have no contact with her? That's my child.
You're not talking to your child while this case is pending.
So you
So
saying
that
I can't
child's
be around my child?
What's that?
So you saying I can't be around my child?
Yes, ma'am, I'm saying that.
What? And I don't like that makes sense. How I can't be around my child?
Ma'am, CPS is involved. A family member has taken custody of your children. And those children will stay with that relative while this case is pending and while CPS is doing their investigation.
So CPS is about to be involved in this?
CPS is involved in this.
And what? So I can't be around my child?
What's that?
And my kids is staying with relative.
I can't. Ma'am, I can't understand what you're saying.
My kids is staying with relatives.
Yes.
I said, which relative are they staying with?
Okay, if you talk to her and don't yell at her, she can understand what you're saying.
I'm not yelling, I'm talking.
No, you're yelling.
A family member has custody of the children.
No, okay, well, I don't want them with my sister.
All right, you know what? She's so combative and it doesn't seem like she's gonna respect the conditions of the bond. So I'm converting the bond. She's not to have any contact with either of the minor children. She can't go to where they're staying without permission of the court or CPS.
I'm just saying that I understand what you're saying, but I don't want my kids staying with my sister.
Okay. All right, she can't purchase or consume alcohol or illegal drugs, can't possess or have access to firearms. She has a $5,000 10% bond.
They tether to whatever.
Yeah, with the GPS tether.
I will be on the tether.
Yes, ma'am.
I gotta be on the tether.
All right, man, sit tight, I'll be right back.
Step to your right to the T. When the light comes on, sign. Ready, state your name.
For the record, could you state your name, Judge? I can barely hear you talk. Could you state
My
your
name is
for the-
Brantley Clark.
And your title, please?
I'm a circuit judge. What's your name?
I am Eden Bay, a sovereign living man. I
No,
hold
sir,
the
you're not.
executive office-
What's your name?
My name is Eden Bay. I'm a sovereign living man of the authorized.
No, sir, I'm
representative
not
of Douglas Young.
accept that.
I'm
Is
the
this
authorized
Douglas, is
representative.
this Douglas Young?
I'm the authorized representative of Douglas
No,
Young,
sir.
created by the public trust of
Remain
the state of
silent.
Florida.
I'm asking.
State of Florida is a
Hush.
public trust
That's
and
enough.
the grantor. I'm the
What's
beneficiary and
he in
executor.
jail
You
for?
are the trustee. There's only one position
No,
left.
Go ahead and take him out, and I'll go ahead and set his bond while he's out. What's he in jail for?
You had him Monday. You had him
That's
Monday
right.
on a trust. Yeah, you did the same thing Monday.
All right, I'm gonna set, he's got fraudulent services. I'm gonna find there's probable cause. I'll set a $5,000 bond on that charge. A $5,000 on the perjury and not official proceeding. His next court date is December 12th. And let's see, I don't think he was asking for the public defender, so I want to appoint him at this time.
That's 5 and 1 because it broke up.
Pardon?
Was it 5 and 1 or a total of 10?
Yes,
Six
ma'am.
or 10?
5,000 on the felony and 1,000 on the misdemeanor.
Yes, sir. Thank you. Come on.
This is State of Ohio versus Douglas Lowe, case 24 CR 1359. We're here today for purposes of arraignment. The defendant was indicted in a 2-count indictment filed on November 21st of this year. Count 1 being harassment with a bodily substance, a felony of the 5th degree, and count 2, criminal trespass, a misdemeanor of the 4th degree. At the appropriate time, the state would like to be heard in regards to bond.
Mr. Watson.
Thank you, Your Honor. May it please the court. It is my understanding that prior to the secret indictment filed in this case, that through Willoughby Municipal Court, that this case was referred for a competency. In turn, my client was referred to inpatient treatment at Central Ohio Behavioral Health. We're going to respectfully ask the court to adopt that prior competency motion filed in Willoughby Municipal Court and have my client evaluated.
As to this indictment?
As to this indictment, Your Honor.
Well, but what's he gonna do is as far as this indictment, entering a plea?
I ain't had a chance to meet with nobody or talk to nobody.
I'm talking to him, okay?
Don't put your
Did he
finger in my
receive it?
face.
He had it in excess of 24 hours?
Your Honor, my client has received his indictment.
That's a lie.
Listen, close your mouth or you'll go away, okay? All right? Go ahead, Mr. Watson.
Let's go then. Y'all ready? Let's go.
He's
Let's
received
go.
his
I ain't even
indictment, Your
talked to no public defender or nothing. I ain't been booked in or nothing. No Miranda rights and nothing read to me.
Okay.
I was arrested in Wycliffe, supposed to leave Wycliffe.
Get him out of here.
Yeah, yeah, get me out of here.
All right, man. Right this
Back
way,
to
man.
jail.
Put your hands in my face. You're gonna pay for that.
Let's go.
Fuck what?
Let's go.
Yeah, fuck you too.
All right. Is he-
Thank Thank you. Getting to the indictment, Your Honor. My client has received the indictment, will waive 24-hour service, any service defects in it, waive reading the indictment, and like to enter a plea of not guilty to the charges. And again,
not guilty plea will be entered. I'm going to refer Mr. Lowe for an evaluation, for a competency evaluation. So he'll be evaluated again. If he refuses to cooperate, we'll send him to the facility in Columbus that already has indication that he's supposed to go there, notification he's supposed to go there to complete the evaluation. I'm going to set the bond at $500,000 cash or surety. Anything else from you, Ms. Alessi?
No, Your Honor. Thank you.
Okay.
All right, good morning. This is 242588, the People versus Denzel Fowler.
Good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service, P86432, appearing on behalf of Denzel Fowler. Mr. Fowler, please state your name for the record.
Yes, Denzel Lamont Fowler.
All right, so I see we're here today for the probable cause conference. Ms. Segura, before we went on record, you indicated you'd spoken with the prosecutor. Is that correct?
I did, Your Honor. We had adjourned the PCC because it was my understanding that the complainant had indicated to the officers that she did not want to pursue this case. She also appeared at his arraignment and indicated that she did not want to pursue. So I had adjourned in hopes that the DV prosecutor would reach out to her to confirm that that is the case and then her appear today so that we didn't have to bring everyone in for a preliminary exam unnecessarily. It's my understanding that contact hasn't been made, so the people are still wishing to schedule that preliminary examination and then obviously see what happens. So I guess we're just going to set this for a preliminary exam next Monday at 9:30, I think is the time set.
Yeah, we have it at 9:30 a.m. 11:25 in person at 9:30 a.m. So we'll see everyone back on that date and bond will continue.
May I address bond if possible?
Yes.
Oh, sure.
Thank you. So Mr. Fowler is obviously out. However, he does have a tether on. I was just asked that the tether be removed. Mr. Fowler has not had any contact with the complaining witness. There's been no allegations of a violation, a tether violation. So I would just ask for that to be removed. I don't feel like there is a danger or risk of flight or anything like that.
No, I'm not doing it. I don't have a DSU. I don't know enough about the case. I know there are minor victims and allegations that a motor vehicle was used as a dangerous weapon.
And
I'll consider it at the next hearing.
Understood.
How many hearings is it gonna be? Because I'd have had plenty of hearings and y'all keep pushing
You're
the
gonna
date back.
have
I'm ready to see my
Mr.
kids.
Fowler, this is not an argument. Okay, there are allegations against you.
That's not that my girlfriend already claimed that was.
Oh, okay, I'm muting you. There are allegations against you, and the case has got to proceed like any other case. There have been no adjournments on this case. This case is moving forward like any other case in the criminal justice system. And there are allegations that you used a motor vehicle to ram into another car that had minor children in it. Well, that's the allegation, sir. And I'm not modifying my bond that I set until I hear some evidence or the case is dismissed. And that's my ruling. So we'll see everyone back on the 25th for the exam. Ms. Segura, that'll be in person. I'm hopeful that you can get some client control before that date. Because if he acts like this in court, in person, I'll hold him in contempt. Thank you. We're all set.
Understood, Judge. Thank you.
In City of Contempt versus Johnny Ray Gregory Jr., case number 25 TRD 25. This case is set for an initial appearance hearing this morning. Mr. Gregory has appeared today with his attorney, Joseph Loftus. Mr. Loftus is representing Mr. Gregory in other pending cases. Mr. Loftus, you are retained on the new case?
I am, Judge.
Okay. Has your client received a copy of the citation that was issued on January 10th, 2025?
He has.
Okay, does he wish to have a reading of the complaint as well as his rights?
Judge will waive formal reading of that complaint, enter a plea of not guilty to the count in that complaint, and ask to be heard on the matter of bond of this case.
Okay, there are 2 counts. One is driving under FRA suspension, and the other is failure to reinstate license. I believe that's been charged with 2 separate counts on that. So not guilty pleas to both?
Yes, Judge.
Okay. The court will accept the not guilty pleas. Okay, you'd like to be heard on bond?
As to bond, Judge, and as you reflected, I know I represent Mr. Gregory in similar cases before your court, those being 24 TRD 761 and 24 TRD 812. I have been retained by Mr. Gregory on both of those, and we are actively working those cases and trying to address the underlying situations in those cases and get Mr. Gregory back on track. And when I mean back on track, I mean being a validly licensed driver. Since the last court hearing, my client has updated me. He has retained new employment through Elite Employment Temp Agency. He's now working at Zirco Plastics, making about $15 an hour. With that temp agency he's working with, he was able to secure transportation weekly to work at the cost of $75. That, plus other family members, will mean Mr. Gregory is no longer driving at this point in time, and I have stressed the importance multiple times with Mr. Gregory to refrain from operating a motor vehicle until he is a validly licensed driver. He is also engaged through Catholic Charities with a caseworker working on obtaining stable residence and hopes to get some of that put into place as well. So he's actively putting the steps forward. He's trying to keep that employment and that income coming in so he can start paying this court's fees or this court's costs and any reinstatement fees. He really wants to have the ability to continue doing that during the pendency of these cases. So for those reasons, Judge, I would ask for a PR bond set in the matter deemed appropriate by this court.
The allegations are that this driving incident took place at 11:45 p.m. What shift is your client working?
What's your first shift, Your Honor?
Look, Mr. Gregory, I'm not expecting for you to respond. I'm going to set this case for a pre-trial conference on the same date as the other pending cases. You are facing a lot of jail time in these cases, and I don't want to hear any excuses from you today or at any time about why you're driving. I'm fed up with you! Constantly being in this courtroom driving against court orders while pending cases are happening. This is constant, well before Mr. Loftus was ever involved in representing you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you. And I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000 personal recognizance, not to operate or be in the driver's seat of another vehicle. Thank you, Mr. Loftus.
All right, Nationwide, go ahead and get it started. What is the monthly rent?
Yes, Your Honor, this is for non-payment of rent. Monthly rent is $1,269. There are no subsidies. Defendants owe September through December, prorated through today's date. That's a total of $4,210, and that's strictly rent.
Ms. Williams, first of all, do you agree that your base monthly rent is $1,296 a month?
No, ma'am.
Okay, do you have your lease?
No, ma'am.
Nationwide, do you have your lease?
Yes, and I'm sorry if I misspoke. It's 1269, Your Honor.
Yes, that's what I have down, but she's saying it's not.
Okay, let me screen share this one.
Okay, so there's your lease up there. The amount of rent is $12.69.
I have never seen the lease before.
Can I see a signature?
I've signed it, yes, but I don't have that.
Okay, so then I have to go by what the lease says. Okay, and you're locked in at $12.69. With
I
a signature.
understand, but I have no idea of this document because I don't have it. I signed it, yes, but I don't have it in order for me to get help. I've been asking for it since July.
Okay, I understand, ma'am.
And this property's been stealing money and everything else from people on there. I've got a violation against my safety rights because I've signed an EARP paper too.
I need
because
you
of
to calm
safety
down
reasons.
first.
I'm
okay?
sorry.
Yes, but you're not getting nowhere doing this.
They're
So
doing
calm
too
down.
much, man.
Okay, so the monthly rent is $12.69. That's all I can do. I have a written lease with a signature. So, Miss Williams, did you pay September through December?
No,
Okay, why not?
because of the property themselves. They don't talk to nobody. They won't answer my calls. They won't answer my emails. They won't speak to me when I walked in the office. They're rude. They're obnoxious.
So you just decide not to pay rent
Like,
since September?
how am I supposed to talk to anybody to pay rent? They won't even accept partial payments. I can't even get a document to go pay at Walmart.
Nobody accepts partial payments.
I understand that, but what am I supposed to do if they're not willing to work
So they
with
never
me?
told you how to make a payment, ever? They just
I
gave you keys?
asked for a new paper for me to go and pay at Walmart because they got people stealing our money orders.
Okay, so have you made a money order that they stolen?
Not in a while, no, because they stopped it after they stole everyone else's.
Okay, so as of right now, you.
But I have
September?
money towards it. I just don't have the full amount.
Okay, so you do agree that nothing has been paid since September?
No. Yes, ma'am. I do agree.
Okay. And you do realize that I have to proceed forward whether there's fraud or not, because you have already admitted you haven't paid since September and you can't stay there for free.
I understand that.
Okay. And so right now, what is it that you can offer them? I understand you have a pending case. And
Right now, in my pocket, I have $400, and that's all I have as of right now. But I get paid every Friday, so I have no problem paying. But I just want this property to foresee better judgment on people.
So nationwide, is this property interested in government assistance?
Your Honor, they do want to proceed with judgment today. They don't accept partial payments. So if she does receive any rental assistance, it'd have to cover the full balance, or she would have to pay the remainder.
Okay. And okay.
If assistance is willing to help with even half of it, then I can sure come up with the rest.
Okay. And just from experience, if they're not willing to give you a copy of their lease or anything, then they're not interested in government assistance. I can tell you that right off the bat.
They're not willing to help anybody on that property, ma'am. They've been going through this for years.
And ma'am, I can't force them to
I
accept
understand
any
that,
government assistance.
But they're all over the news. Do you understand what they're putting our families through, my babies through?
Then you can go hire an attorney and you can file whatever lawsuit you feel is necessary for them.
Like, y'all, they place an EARP paper for protection against my ex-husband, and they're still doing this.
I don't know.
I filed housing papers when I filed my lease. I filed housing papers and have been pending for a while, and they still ain't doing nothing.
Then the only thing I can tell you, ma'am, is to hire an attorney.
Who can afford that?
Oh,
I just came from one eviction in a hotel to another crappy ass apartment complex that's doing me this way too.
and well, we have legal aid out there as well that's legal based, that's income based. But as far as I can't give you any advice on the bench. All I can tell you is to contact an attorney or file your own
People
lawsuit.
shouldn't be allowed to treat people this way.
Judgment's going to be in the amount of $42.10. You do have
And
five.
I don't even owe that amount at all. I know I can tell you that for a fact because they dumped a whole bunch of charges on me.
So I just asked you if you agreed to that amount and you said yes. So
5,000, yes. The rest of it that they say I owe, I don't.
your judgment's only for 4210.
Well, it's still wrong.
Okay, miss.
Thank you, Your Honor.
Have a great day.
Your name, sir?
Timothy Kelly.
I have two motions up. I have your motion to set aside the default.
Put the picture of my daughter here. She's an occupant. She wanted to be here to say something, but she was in school.
Okay.
Thank you.
That picture is not gonna happen that way. You're not gonna sit up there and display things to the court that way.
Okay, I asked first. I'm sorry. I've mentioned her a lot, so I just wanted you to see her.
All right, let's deal with your motion first, Mr. Kemp.
Okay. Come on, Your Honor, did you get the evidence package, the exhibit evidence? I asked the girls when I walked in. Girls, I mean the nice ladies up front.
I have these picture exhibits. I don't know if Ms. Dornbush has them or not, but
No.
I have them.
Okay, you do have them?
Your Honor, I do not have them, just so the court is aware.
All right. I thought they were both sent because I have a double thing where you could send group, and I sent them. At any rate.
Okay. All right.
Your Honor, I just, with due process, the most important thing is being heard, and I haven't been able to be heard yet and state my case and defending myself with all these accusations. And, you know, that's why I know I missed the trial, but there's all kinds of things, reasons for it. I've met all the demands of the court. If you remember, I was before you for 4 or 5 months in a row dealing with the rent, and we made decisions and I lived up to the demands and so on and so forth. So I did you read the motion where I gave you?
I have read everything that comes in this.
All right. I didn't know. I'm just, I want to have a trial.
Sir, I gave you that opportunity to have a trial on October 30th, and you failed to appear.
I know, but fails to appear sometimes happens. Can I read something to you, Your Honor? This is all diversion programs and sent down by the Attorney General to try and help tenant landlord disputes. That a judge could take a proactive role in the hearing by ensuring that both parties know.
What are you reading from?
It's recommendations from, we never even got a chance to talk or settle. I mean, we had a last settlement conference, but we didn't talk about anything. And before that, the attorney and the landlord, the property manager kept me from talking to him. We couldn't even try and settle. And throughout the whole thing, all the legal stuff that I read is that you try and work it out before the eviction case. And also I have, this is for sure a retaliatory eviction, and you wouldn't even let me speak on it the one time I brought it up because.
Sir, you know what?
What? If you give me a trial, Your Honor, did you read the character references my neighbor sent you?
Do not come here.
What?
At this hour, questioning me about what you think I haven't read. I have just told you that I read everything in the file.
I apologize.
Do not come here before me, because all of these people have been sitting here. They've been here, and tell me ever that I won't give somebody an opportunity to be heard. Do not insult this court that way. Do not insult me that way. Now, if you want to start your argument again, you may, but you will not sit here and impugn the character of this court or of me with regard to listening to tenants and landlords regarding these proceedings. And you will not attempt to try to school me with some literature as to how to handle a case. I have been doing, you know what?
What?
I'm gonna pass this case and because I want to make sure that I'm listening to you. And I don't think these other people that are sitting in here should have to wait through your shenanigans. So have a seat.
I'm confused, Your Honor, please. I didn't say it was you. I said due process. That's all I said.
Have a seat.
I wasn't saying anything.
Have a seat and keep your mouth closed. You throw something down again, we're going to have a problem. Will you throw something down again, we're going to have a problem.
Sorry.
Let me retry this. Court recalls the case of River Ridge versus Timothy Kelly.
This is your motion to set aside the default judgment. There are two parts to the setting aside of a default judgment before you start going on. The first part is that you have to have good cause for failure to appear. State every reason for your good cause for failure to appear for the trial.
Oh, you want me to state it now?
I asked the question.
Okay, I'm sorry. I thought you were making a statement. Well, as I iterated in the motion, that one, I don't have transportation. It's very hard to get it. I don't have the money for an Uber or a taxi or any of that. If you recall, I told you, for one of the hearings, I rode my bike 30 miles round trip. So it's not that I wasn't trying to get here. And I also, right from the beginning, everything I've told you has been the truth. I mean, in the beginning of we had trouble with the rent. I told you that I was also going through litigation with the friend of the court. And as a father, that's a very hard thing to figure out and such. So that's one of the reasons was my daughter called me that night. She had an emergency and I had to take care of it. And she was with me the next day, the trial day. And
we received no notification or phone call from you indicating that there was some delay or some reason why you couldn't be here that day. Is there a reason why you didn't call the court?
Yes, and I'll tell you, that week I had dropped my phone and it broke and I had no way to call anybody. I didn't have any way to get any of my trial stuff out. I couldn't access anything. I didn't have the money to buy another phone. So for 4 days, 5 days there, I was in purgatory, so to speak, without being able to communicate, without being able to get anything off the phone pertaining to the trial or this case. And that's the truth.
You mean you couldn't have found a place to call from?
Pardon me?
You couldn't have found a place to call the court from?
Yes, well, I was in the middle of this. Look at my child. I don't want to put it on record yet because has to do with some serious things going on with her safety wise. So, and I didn't know, it's very hard I don't want to, can I ask you a question about the trial? I mean, I don't want you to think I'm questioning your judgment, but I'm confused about why it was set on to the bench when I demanded a jury trial way back.
We have already gone through this. You failed to comply with the escrow order. Plaintiff was entitled to a trial as to the issue of possession, an immediate trial. I set it out a few days. We have been through this. I'm not relitigating everything, nor answering all of the questions that I've answered for you in the past, Mr. Kelly. I'm just not doing it.
I don't recall us talking about whether it was going to be a bench or a jury. Honest, Your Honor. And I've
Your Honor,
met,
I can state the exact date that this was addressed because I specifically emailed the court to clarify if the jury was waived and was able to verify. So I can remind the court the exact date that that conversation happened.
I thought at that time that it was a,
I'm not going back over this.
Your Honor, if you would listen to, if I could cross-examine witnesses and bring my witnesses in, you'd see a different light on this, I swear. I haven't been able to present anything. You don't, I mean, may I ask you another question that I don't get? I'm not questioning you, but I wasn't there and I don't understand how it came to the trespass and the witnesses that I can't go around them. What was said that you think I'm a danger to the community?
It wasn't an issue of you necessarily being a danger to the community. They were trespassing you after the writ would issue. It's as simple as that.
Okay, well, I mean, those were a couple on the list were friends. I mean, I get along with Kevin, and so I didn't understand why I was out, you know, but it was a good reason. I want you to know the facts of the case. That's all.
The second thing is that you have to state to the court a meritorious defense. Please state your meritorious defenses, Mr. Kelly.
Well, can you help me out with the meaning of that more?
No.
No? Okay. Well, you know, I know have a right to counsel, but all the resources are used up. I have tried for since this case began to get some help from the state and all the resources that are listed, you know, and they're all filled up. I think it's hard to even express because I'm afraid I'll offend you. And
sir, do not try to blame me.
I'm not blaming you
this
at all.
You just need to say what you're going to say.
Okay, well,
I don't think that there's anybody that comes before this court that would at all indicate I don't listen. I may not agree with you, but I will always listen. So don't try to put it, poor me.
No.
Somehow this judge won't listen to me.
I'm not.
Say what you have to say, and then I will make my decision.
Well, I had all kinds of things written down. I started to read it and you said, don't read that to me. Well, I don't know how to present. Can we go over the evidence? May we do that? I marked all the.
Your Honor, I would object. I've not seen this evidence that Mr. Kelly is referring to. It certainly wasn't attached to the motion that I received. I don't know when it was filed with the court, but I've not seen this evidence to be able to comment, to be able to prepare any sort of response to it.
It pertains to my oral argument already on the record, Your Honor.
I'm going to sustain her objection. You can't come here with new things expecting for the opposing side to respond to them.
Well, I was going to fill out.
It doesn't work that way.
Okay. I was going to fill out an amendment to the motion, but I've been up all week, all night trying to just get the proper paperwork into you and do it all right. It's not easy being 95% of us tenants don't have lawyers. We're pro se. So, I don't know where to get any help as far as the legal, but she has been able to bring the list of the original offenses. She's added on to that throughout the trial. The plaintiff has. I mean, now my dogs, first it was just 4 items. And she's brought up my dog. So she's added on without. So I'm just confused about the way to present evidence, I guess. She brought up my daughter missing a day of school. Where did that come from? I mean, all of those have been.
I didn't mention his daughter at all, Your Honor. I'm sorry.
It's in the transcripts. I can't pull it up right now, but it's there because it bothered me. Honestly. I mean, I don't know how to present to you. Why don't I get to present the retaliation defense? You haven't listened to what
Sir,
happened there?
I need meritorious defenses you have to this claim.
You can't tell me what, may I look the word up in my phone?
If you can do it quickly, you can go ahead and do it quickly.
Never mind. Okay.
No, go ahead and look it up.
Your Honor, Mr. Kelly is retrieving his phone. I just want to make the court aware that I would like an opportunity to respond to.
Oh, absolutely. As soon as we can get there.
What's the word, Your Honor?
Meritorious.
Meritorious. Could you spell it for me?
No.
Okay. See. Oh.
You filed the motion.
Yeah, I probably should have paid attention to that.
Yeah.
Well, it's hard. I've been reading everything in the law. It's the only way I can do anything. And there's a lot to take in, Your Honor. The delay, suspension of an act. Oh, okay, I know. I did read that. That's kind of like what they did for COVID with the money. Do I have that right? Sorry.
I don't know what you're talking about.
Well,
I have no idea.
Is it moratorium? I'm sorry. Okay. My defense is that I just want to be heard. And I didn't say that you did anything wrong to make that not happen. But with reading all the stuff in the legal that you have to read if you're pro se, you know, I'm not an attorney, but I'm starting to at least learn some of the laws between tenant and landlord, and everything I read is the land of America is trying to the courts handed down by the Attorney General and the Supreme Court on helping the litigants, especially the tenants, because they're the ones that are come to you with no resources as far as money for an attorney or any of that. And the landlords always have the best attorneys. Like I said, 95% of us are pro se. So all I can do, and I told you an attorney called from Michigan Legal Help, but he just left a message and never got back to me. And so I have to read on these motions and read on the appeals or read on how to go about a defense. And when I present
No, come back. Okay. Well, can't, no, I was gonna make, I think you should stay too. Go ahead.
When I'm trying to present the retaliatory eviction, there's all kinds of writings on that in the law. So it must be something that happens in court or they wouldn't have it in there, correct? I mean, I'm not a bad person. I want you to know the truth, Your Honor.
I'm not saying you're a bad person. Miss Lee, you have a reason. Is there a reason?
I'm sorry, Your Honor. I did want to corroborate Mr. Kelly's account. He did get in touch with our hotline, our housing intake line. We have been trying to give him advice over the phone, but we do not have the resources to represent him. If you would like me to sit with Mr. Kelly for a bit and try to assist him a little bit further, I'm happy to do that.
Okay. If you're willing to do that, Ms. Dornbush, I'm sorry to hold up your evening, but I will allow it to happen because I'm probably one of the most unfair judges I've ever met, but I'm going to try to be fair. Mr. Kelly, can I step away from the podium?
May I give you a compliment, please, Your Honor?
No,
okay.
Do not give me a compliment. Do not say anything to me at this point.
All right.
Handle Mr. Fink's cases, Ms. Dornbush. Sooner or later, you'll be able to go home.
Okay.
She's going to be mad at me.
I would never dare.
I tried. River Ridge versus Timothy Kelly. If Ms. Dornbush.
I am still here, Judge. Yeah.
I called the case. What are we doing?
Well, Your Honor, as far as what you asked me about the defense, I just want to make a notation at the bottom. It says, upon information relief, resident has failed to remedy the violations after being given an opportunity to cure. Thus, grounds for termination exist. I did cure all of them at the time they asked. Every time they ever asked, it was always, I always met their demand, whether I liked it or not. So I would like an opportunity to go to trial and defend this and show you that. And as far as any verbal abuse, I put in one of my letters that, or one of my motions that somewhere there's a phone call of that, because it was a three-way conversation, and I didn't know if I needed to look it up or not. But as far as the upon information belief and all those lists, please, I deny them, and I can go one by one if you want. I'd just like the opportunity to show you and cross-examine witnesses if there are any, trying to accuse me of this. I adamantly deny most of what's on here. I mean, there was the car, we talked about it, on the grass, but that was during the settlement conference. During what I was just trying to explain to you is that's not how it was. It says parking on the lawn on or about. That car was on the lawn for about 3 months, and then she asked me to move it to the drive. We pushed it to the drive, and then it finally got towed 3 months later for expired plates, because the car wasn't running but it had legal plates up until that point. That's all I was trying to explain that one day about the car when, the final settlement conference. I wasn't disputing that at one point it was on the lawn, but it's kind of, and I don't know how that works, but I do have witnesses for most of these to dispute them. And I don't know if you have that in front of you, but doesn't that read like if the cure was given, that there wouldn't be grounds for termination, or am I reading that wrong? Because I did cure everything they've ever asked me to do as far as moving.
All right, Ms. Dornbush, your response.
Thank you.
Oh, I'm sorry, I don't have.
Go ahead.
I'm waiting for Mr. Kelly to get his hearing device.
Thank you.
Your Honor, at the outset, when Mr. Kelly first began speaking, he made a statement that he has complied with all demands of the court. And I want to first address that statement because that's absolutely false. Mr. Kelly has not complied with all the demands of the court because he was ordered to do several things early on and he did not do any of them timely. Most recently, he did not pay the full October rent into escrow. He did not pay November rent into escrow. He did not pay rent into escrow with the motion that he filed, even though he checked the box stating that he did. He made a statement, Your Honor, that there was no opportunity to settle this. That is also false because Mr. Kelly and I had a very lengthy conversation back in August, at which time we did attempt to settle this, but the settlement offer that I was authorized to make was not something that Mr. Kelly was satisfied with. The only settlement that Mr. Kelly wants is an agreement by my client that he can stay, and that's not something my client is going to agree to, and I made that very clear to Mr. Kelly. Your Honor, with respect to Mr. Kelly's motion and his statement that he has good cause for his failure to appear, he put many things in his motion, Your Honor. I would say the majority of them have absolutely no relevance to the issue of good cause. That is delineated in the response that I filed with the court. And Your Honor, just for Mr. Kelly's awareness, there was a glitch in our system, and the address that I mailed my response to, which it went out day before yesterday, so we probably wouldn't have been delivered by today anyway. It's not going to go to him. So with his permission, I will email him a copy of it if he wants it for his records. I'll stick it in the mail as well, because I do have his email address.
Okay, yes. Well, you have the court permission to do that, understanding what you just
I don't have a problem.
Thank you, Your Honor. The specific issues that he put in that I believe have absolutely no relevance to the issue of good cause is that the court being aware of his transportation issue and is having to ride a bike to the court previously, he somehow managed to get here every time. Further, for this specific motion, or excuse me, the trial date, Your Honor, Mr. Kelly stated he had a ride lined up and he chose not to take the ride because of another reason, and we'll touch on that in a moment. But he had a ride lined up and he has a ride today, I believe. My client's here and sees that there's another resident in the community that she believes may have driven Mr. Kelly to court today. So clearly he has the ability to get transportation here. As the court noted, Mr. Kelly didn't call the court. And Mr. Kelly made a statement that his phone was broken. But Your Honor, I seem to recall, and maybe I misheard, but in this hearing, when questioned about why he didn't call the court, he said he didn't have a phone. But just a minute before that, didn't he say that his daughter called him about an emergency?
The night before.
Daughter was able to call him the night before. If his phone was broken for the 3 or 4 days before that, somehow he didn't have a phone the morning of court to call. But not only that, he's obviously got people in the community that are there to support him. As the court pointed out, he could have borrowed a phone from anybody. So I don't believe that Mr. Kelly has stated good cause. For the additional reasons stated in my motion, Your Honor, he stated his belief that he'd be given a break because default was a possibility, may enter. But Your Honor, Mr. Kelly's been in court before and failed to appear and a default judgment was entered against him. And I referenced that particular case number in my response. Your Honor, he referenced his concern related to his alleged request for a jury trial, but the court has already touched on that. And Your Honor, the date, just for the record, that that particular issue was addressed was September 20th of this year. He cites an alleged case with the Michigan Civil Liberties Department, and I assume he means the Michigan Department of Civil Rights when he states that. Again, has no bearing on his good cause for appearing at the trial date. That he was finally in touch with an attorney from MI Legal Help. Again, no bearing on his good cause for failure to appear, and that he intends to file appellate pleadings. Again, no good cause for his failure to appear. Your Honor, this emergency with his daughter, I'm sympathetic to whatever's going on in his family situation, but Your Honor, Mr. Kelly has been stating various times throughout these proceedings that this alleged custody issue has interfered or detracted from his ability to meaningfully engage in this court process. And Your Honor, I personally did a search of the Circuit County Register of Actions. I don't see anything pending in that case. My understanding from what's available on that Register of Actions is that Mr. Kelly's ex-wife has sole legal custody of his daughter. And one of the police reports that we were able to obtain from the Michigan State Police, and I believe it's from sometime last year, I don't have the exact date, that there has been no change in that. They specifically referenced that his ex-wife has custody, full legal custody of his daughter, and that there's been no change to that. If there's been some change between 2023 and now, Your Honor, it's not showing on the Register of Actions, but there's nothing pending showing in that case with the Washtenaw County Circuit Court. Your Honor, with respect to this alleged meritorious defense, first off, we've already addressed at the settlement conference before Mr. Kelly was taken into custody for that bench warrant, why additional things were added and more specifically stated in our complaint for termination of tenancy. And that is because the demand that was issued, Your Honor, states reserves the right to bring this and other issues that are lease violations to proceed on the termination action. And so at that court date, Your Honor, which was approximately 3 weeks ago, Mr. Kelly had notice of what additional grounds would be relied upon by plaintiff. One of those issues was an actual admission by Mr. Kelly with a photo he provided to the court of his dog sitting outside on a tie out. Community doesn't allow that. And frankly, Your Honor, the dog was tied out again today. Mr. Kelly nowhere in sight. My client is signed into Zoom right here, and she could tell the court that, again, the dog was tied out. Mr. Kelly was not out there with him. Minor violation of the rules, Your Honor, yes, but it's just a continuation of Mr. Kelly believing the rules don't apply to him, Your Honor. And that's unfortunately been how this process has gone throughout. Every time the court has ordered Mr. Kelly to do something and he didn't follow through, there's just been some reason why he should be given leeway and that he shouldn't be bound by the orders of this court, the rules of the community, the laws of the state of Michigan, Your Honor. Speaking of those laws, Mr. Kelly has still yet to state any defense to his driving in the community, probably since 2017, without a license. The lease that he signed clearly states He is to be in compliance with the laws of the state, local ordinance, federal law. And Mr. Kelly is in violation of Michigan state law by driving without a license in the community. He's been living there since 2017, and I believe he acknowledged at the settlement conference on the 22nd of October that he hasn't had a license since 2017. So that on its own is sufficient grounds for this court to grant a judgment of possession. And I believe Your Honor even alluded to that at the last court date and still gave Mr. Kelly the courtesy of having an opportunity to appear for a bench trial and bring his witnesses. With respect to this alleged retaliation or retaliatory eviction, Your Honor, the statute is very clear on what constitutes retaliation, and Mr. Kelly has yet to cite anything in that statute that my client, that he has done that would bring about a claim of retaliation by my client. But even if he had, Judge, that is a rebuttable presumption. And my client would still have the ability to show that they have legitimate grounds to terminate Mr. Kelly's tenancy. Your Honor, at that settlement conference, it was discussed how Mr. Kelly's answer was deficient for a number of reasons. One of those things being that he in no way addressed the specific issues that were referenced in the termination of tenancy notice, that being the animal loose in the community, disturbing other residents, parking on the lawn, failure to maintain the home and site, verbally abusive towards management. He's addressed a few of those things today, Your Honor. And my client would acknowledge today that certain issues with respect to violations relating to condition of the site were addressed. But as we discussed at length at the October 22nd hearing, Your Honor, with respect to the vehicle, it's sat there for months after violations. And Mr. Kelly didn't do anything about it. My client had to ultimately have the vehicle towed. So there's a violation right there that there's clearly no defense to. With respect to the verbal abuse of management, Your Honor, how do you cure that? You can't go back and take the words back. I mean, it happened. So that's not really a curable thing. With respect to disturbing other residents, that's something that continues to happen.
That's not true. I mean, that's just a statement.
Mr. Kelly, I didn't interrupt you.
Oh, I'm sorry. I
I'm
can't
not-
talk. I thought you were done.
will
I'm
have
sorry.
You will have an opportunity
sorry.
to respond. But Your Honor, we talked at length on October 22nd about how Mr. Kelly's answer was deficient because it didn't address those things. And in filing his motion, Your Honor, he still doesn't address those things. The only things that he brings up is this alleged audio recording that he thinks will prove retaliation. But that's not going to be sufficient. The statement that he's provided does not give any detail, which is the issue that was precisely stated at the hearing on the 22nd. And Mr. Kelly is still not following the rules and now expects the court to give him leeway again. The court has already done that by setting the matter for a bench trial on the 30th. Mr. Kelly's own motion, Your Honor, clearly states, I made the decision not to come to court because I didn't want to bring my daughter. He made a calculated decision based on the circumstances not to come to court. And he has not set forth anything in his motion that should change that outcome. Respectfully, Your Honor. And so I have to ask that this court deny his motion and allow the judgment to stand.
Your Honor, I want to address the motion itself. She had brought in I meant to put that under the ex parte where I marked the money to go into escrow.
But there was no escrow filed.
No, there wasn't, but there was a box. Your Honor, when I was before you, it was, you know that I have money problems. I have a fixed income coming in every month. And when that comes in, I can pay any arrearage. I mean, and that's what I was speaking to when I met the demands, when only in the money, I wasn't talking about here, but when I went before you, I've been going before you for the last 4 or 5 months before the just cause. And what I was saying was that, you know, when you said pay on this date and the court said we did, except the one time when I was $43 short, which she'll probably bring up. And regarding the settlement agreement, I was going through these. In fact, I was on the car on the lawn discussing it and speaking to you, Your Honor, when you discovered the warrant thing, and then I was taken out. And when I came back, we didn't discuss anymore. So, I mean, I don't know how I can address it better than that. We were addressing it and going down the list, but then I didn't, I didn't get to, but it's kind of hard. I'm trying to follow her. Some of these things, she says that in my answer, I don't explain things. It's kind of general. Well, this stuff doesn't either. It just says that, she's stating that the abuse and threatening of staff, I have yet to hear, what are you talking about? I mean, we can all throw out things out there, but what did I say? Who did I say it to? What was it? Because I can remember that conversation and the incident because that coincides with the electrical cord. So, I mean, I mean, these are kind of vague too. I don't know how to defend them, but there is the reason there's a civil right, and I did put the letters wrong, but as far as the Michigan Department of Civil Rights, that I do have a case number or a complaint number, and that's for the very reason that I've been trying to explain to you about the differences in her, her writing me up, or the landlord or the property manager writing me up and not writing the neighbor up for the exact same thing. I mean, that's listed in discrimination by the state of Michigan. I read it, and it uses an example like that. Like if you have a resident here or a tenant here that is late for their rent, and you go in and make a move on them, but across the street is the same exact thing. They're late on rent, but you don't there. That's a civil infraction from what I've read, or it's discrimination. And that's what's going on here. That's why I kind of brought in, sent those pictures to you. I mean, and as far as the day I missed, that was a terrible week. It was my responsibility. I say that in my motion that I got cuffed and thrown in jail. But, I get home and I'm on this website that I've never seen before. My daughter brings it in, and it's you, and it says contemptuous defendant goes out the back door. And gosh, the comments were brutal. I mean, brutal. It's not up anymore, but it was, and my daughter actually answered to some of it. So that week was just brutal. But I said that about my daughter because and the neighbor that drove me here, he's left, so I'm stranded again. But he will attest that we were ready to. He was my ride. He usually is, and his car's in the driveway right now. It broke down, and I did try to get other rides, but everybody's at work at that time of day. So what I meant in that was I did have my daughter. If I do get a ride, I got to take her. I wonder if
but you said you had made a decision not to.
Well, only because I didn't know if it was allowed at the court.
No. You're telling me you had this and this is what you would have done. But your motion says you had made a decision because of your daughter not to come to court. You can't have it both ways.
No, I know. I explained before that but I was going to bring her, Your Honor. That's what that meant. But I said I don't want to make you mad again because I didn't know if minors were allowed in here. I mean, it explains that before that. I mean, she wants to, she's 13. She wanted to make a statement to you about it because it's kind of her house. But that's not what I meant by it. I take her everywhere since she was born. I have no qualms bringing her, but I meant that because I tried to find rides. We couldn't find a ride with the neighbors. They were all at work. John's the only one that can give me one. Car still broke down in the driveway, Your Honor.
Your Honor, may I respond?
Go. Please. Keep going, Mr. Kelly, whatever you want to say. I mean,
I can tell we're where it's going, and I'm not an
You
expert.
can't tell anything about.
Okay, maybe you're right. I'm sorry. But this is very tough to just present it in a professional way and say it as I mean, but that's honest. I mean, I was trying to get a ride here, but that was the final decision. So I don't get a babysitter for her and go hitchhike down Michigan. I just said, since she's here, that was just meant that I made that decision after I couldn't find a ride. But I haven't skipped your court dates. I'm looking to save my house. I mean, and it's not necessarily,
Mr. Kelly,
it's not necessarily to stay there, Your Honor.
Mr. Kelly, I'm going to stop you because
Okay. May I say,
you just sat here, tried to tell me some story about that you were going to appear. I'm going right to what you filed with this court.
okay,
I have good cause for my failure to appear. I did not appear / answer because, I did not go to the court because I had an emergency hearing regarding my 13-year-old daughter the night before. Says nothing about you actually bringing her. Says nothing about her coming to the court as though you just represented to the court. You didn't come because of her. I'm done.
I don't have it by memory.
I'm so done.
Please, Your Honor, I just want to.
Mr. Kelly.
You're going to tow my house away with all my possessions? Not you.
Mr. Kelly, I am going to follow the law. I've listened to you all day and you keep going back and forth in some of these things. But I'm ready to rule. I've listened to the plaintiff. I've listened to you.
Please give me a trial, Your Honor. Please.
All right, Mr. Kelly, I gave a trial date for the parties to be here. It should be noted, although plaintiff didn't say much about it, plaintiff was here with all of their witnesses waiting for you to appear. Everybody interrupted their day. They were here ready to go and you didn't appear. And quite frankly, from the court's perspective, the court doesn't hear from you for a good 9-10 days after the trial date. Don't hear anything about what happened, this, that, nothing.
Sorry, Your Honor.
No, you don't have to be sorry. I'm just saying, you're distorting what has transpired. Plaintiff was here, ready to go, ready to, I'm presuming, state with specificity, have testimony and evidence regarding every one of their allegations. You do not appear. Your notion that you've been following the direction of the court, not true. I had to beg you to get an answer into me. I finally got that to happen, told you to pay escrow, you didn't do it, and then still didn't comply with the escrow issue. You may have your reasons, but don't say you followed the direction of the court when you didn't, and you know you haven't.
I guess I tried my best.
You know
I'm
what,
sorry.
Mr. Kelly, I have listened to you all day.
Right.
Now is my turn. I do not want to be interrupted. So for the reasons, part of the reasons regarding your, as I've indicated, there are two prongs you have to satisfy. One is you had good cause for not appearing. You have by no means established that you had any good cause whatsoever from appearing on that date. Now, you make it sound regarding your arrest on the bench warrant as though somehow or another you were manhandled, put in jail, locked in a cell, way down. Let's be real about what happened. You got locked up because there was a valid bench warrant out of 14A4 district court. My court, but handled by another judge. That judge, as I told you, happened to be here that day. We took you into custody I spoke with her to make a determination as to what to do. And one thing you never said about it, ever, because you're just trying to create sympathy, is you were released that same day. Told what your trial date was, told everything, and you were released without having to post. In fact, when you came back, I arraigned you on the bench warrant and gave you the date to go appear for your driving while license suspended. So don't make it seem like somehow or another this evil judge all of a sudden locked you up on a driving while license suspended and just left you sitting in jail, and that because of that you could barely get yourself out of jail and then appear for trial. That's not what happened. Do not interrupt. And then you sit here with these meritorious defenses or whatever you're trying to claim are defenses. I agree with plaintiff. You have not established any of those defenses, particularly the one you keep trying to harp on, which is the retaliatory conviction. There's a predicate before you can even allege that. You've not even gotten there. Nothing you've alleged is even close. So you don't even have to go through a further analysis of it. You haven't started that type of action against the plaintiff. You've not stated it and haven't shown anything regarding that. The cold-hearted reality regarding the meritorious defenses is, and this is just the reality of how it works, plaintiff would have to just show one, and it could lead to your termination of your tenancy. When you place yourself in this position, you have to show me a meritorious defense to all of their claims. You failed to do that. I honestly don't believe that you've established even one, but you certainly have not met or established any defense whatsoever to any of these claims. I'm done. You just haven't established. And so for those reasons, your request to set aside the default judgment is denied. The court specifically finding that good cause nor meritorious defense has been established. The judgment will stand, the writ of restitution will issue. Because the writ of restitution is issued and there hasn't been a written answer filed to the motion to remove the manufactured home and the time has passed, the court will also sign that order and grant that plaintiff's motion regarding that. I am.
All my
Thank you.
stuff's in there, Your Honor. All my daughter's stuff, the neighbor's stuff. And my equity in the home. I want to say thank you that day. I did say thank you. It's on the record for you letting me go home that day I was caught. I was very grateful for it, so.
Your Honor, I believe I submitted proposed orders for both, an order denying
Yes.
attendance and a motion, and an order granting our motion.
And I have signed that order. I have signed the writ, and I have signed your order regarding the removal of home.
Thank you.
You can complete it, and then you can refuse to go to NeoCamp, and then we'll come back. Or you can get your shit together.
Now, I know this judge always divides the room. Some people love him, some people hate him. That's fine by me. For me personally, I kind of like his no bullshit approach. Now, a lot of people don't like the fact that he swears. I get it. But I don't know, kind of brings a bit of realism to him. But maybe that's not what we need either. Maybe it's the neutral kind of aspect of it that we need. That's a really great question, actually, and I'd love to get your take on that. Should judges be a bit more personable and real, or should they do, as their robes intended, keep them neutral and almost robotic in a sense, I guess, or just part of the machine? I don't know. Interesting one. I'm not 100% sure how I feel about it either. But anyway, we got this guy here. And he gives this big, long sob story. Woe is me. I'll do better. Yada, yada, yada. Judge is like, the hell you will. Have a look at this. Let me know what you think. And we'll catch you in the next one. I'm working on a really interesting one right now as well. So stay tuned for that one. Sláinte.
Mr. Rhoda?
Thank you, Judge. Before you this morning is case number 24-CR1415, captioned State of Ohio versus Jeremy Thomas. Case was last before the court, Judge, on February 12th of 2025. At that time, the defendant pled guilty to 3 counts. Count 1 was a charge of operating a vehicle under the influence of alcohol or drugs or a combination, a felony of the 4th degree, violation of ORC 4511-19A1A. Count 2 was a charge of unauthorized use of a vehicle, a felony of the 5th degree, violation of ORC 2913-02. It's a felony of the 5th degree because the victim was an elderly person. Count 3 was a charge of failure to stop after an accident, a misdemeanor of the 1st degree in violation of ORC 4549-02A. The defendant is present today in court with counsel. Mr. Watson, we are here for purposes of sentence.
Mr. Watson.
Thank you, Your Honor. May it please the court. Mr. Thomas is a troubled man who's got an issue with drugs and alcohol, specifically alcohol with this particular case. My client admits it. In the pre-sentence report, I think he was pretty open and honest. He has a severe drinking problem, and unfortunately, he compounds that issue by continuing to choose to get behind the wheel of a car and operate it. Your Honor, my client, early on, when I met him, wanted to take responsibility for this. I believe he pled by way of information. He wanted to address this matter. The issue, the reason that this took as long as it did from the plea to today for sentencing is my client this entire time just felt that it wasn't even worth jumping through any more hoops, that because of his record, it was just automatic prison for him. Quite frankly, Your Honor, and I have not heard this from him, this is my own personal viewpoint assessment, but I think Mr. Thomas, quite frankly, has given up on life. And I think it's sad. I know while he was in our jail, he's made various threats for suicide. I know he's been put on suicide watch. I know initially we had a sentencing date about a month ago. He refused to cooperate with probation totally. He did reverse course on that, and at the very least cooperated with the probation department and Lake Geauga with their drug and alcohol assessment. Granted, yesterday NeoCap tried to interview him. He did refuse that. But Your Honor, my client, again, is a troubled man, and I know that there's mandatory time here with the OVI. I know that there's mandatory, that the court has the discretion between local time or prison time. With respect to the prosecutor, because I know we've had discussions on this, early on, we have a joint recommendation for 9 months on this case. However, yesterday afternoon, Mr. Thomas called me. I guess there was a glimmer of hope put under him that he might be eligible for treatment. And I think, Your Honor, I think that's what he needed to hear in life was that there might be something. And he called me at the end of the day. I had to leave a little early yesterday to take care of my kid, explaining this. So I want the court to hear it directly from Mr. Thomas, because I know he hasn't been very cooperative. I know his record is horrible, and I know under most circumstances this court probably wouldn't even consider this request. But I think Mr. Thomas is sincere when he called me yesterday. I briefly spoke to him before Your Honor came out. He told me he's prepared to speak. So at this point, Your Honor, I'm going to ask the court to either consider what Mr. Thomas would like or the joint recommendation. Thank you, Your Honor.
Mr. Thomas, what do you want to tell me?
Your Honor, I just wanted to address the court and let it be known that I wasn't trying to not comply with my pre-sentence report. I just didn't have any hope that I would possibly get treatment or probation. And I spoke with the forensic psychologist, and she, after we had spoke, she told me that she was going to recommend 90 days in Lake Concord Pines or a treatment facility. And I asked her if possibly after that if I could go to a sober house, because I would like to get a home group and a sponsor so that I can stay sober, because I'm just worried about other people's well-being, and me behind the wheel of a vehicle is dangerous not only to myself, but to everybody else around me that could possibly either get seriously injured or die. And I just don't want that to happen. So I'm willing to try to get some sobriety and change for other people's well-being as well as my own. You know?
Didn't you just do the jail treatment program last fall?
That was a year ago in March, yeah.
Well, I think it was in the fall, but whatever. Okay, it was recent. So what did you do with the jail treatment program?
I successfully completed it.
What does that mean? What does that mean, successfully completed it?
Well, I successfully completed it as far as when I got out, I was seeing Signature Health for my psych evaluations, and I saw a psychologist and she prescribed me medication, but it wasn't a full assessment, so I never got diagnosed with anything for the Abilify that they gave me. But they also gave me a booze bar for anxiety, which I do have social anxiety, and I think that's one of the reasons that I drink, is because it makes it easier for me to communicate with people.
And it keeps landing you. I assume all these theft convictions over the years, the drugs and alcohol are tied in, right?
Yes, sir.
Okay.
And the disorderly conducts.
Right.
It's all alcohol. Yeah.
Okay, so why would this stop now, as opposed to the last 25 years?
I really haven't tried to get treatment any other time, Your Honor.
Well, you went to treatment. You went to the jail treatment. And now, I don't know how hard that is to complete successfully in their terms. I imagine you could do the minimal amount and then successfully complete it, right? So it really isn't successful. Okay?
No.
It checks a box for statistics for them, is all it does.
Yeah, it's only a 30-day program. It's not really helpful.
Why did you refuse to see NeoCap yesterday?
I don't believe they ever came to see me, because they did.
They tried to see you and you refused to see them.
I don't remember. CO's never told me that anybody was.
When was that, Kim? Okay.
I don't. They never came and got me. The COs never came and got me to see NeoCamp.
So, well, I don't think Jan's making that shit up. Okay, she sees people all the time, and if there's I don't think there's a conspiracy with the guards against you.
No, but I would.
So you can't. What you've done the last 25 years hasn't worked, right? Because you keep going to prison.
Yes, sir, yeah.
So why is it magically going to work now if I go along with you?
Because I'm serious, and the other times I wasn't mature and an adult. I'm 41 years old, and I'm just sick and tired of being sick and tired. And I mean, the hit skip that scratched somebody's paint, someone could have got seriously injured, and it's just something that I don't want on my conscience. I lost my daughter in 2017. She got hit by a car and killed, and that really took me downhill with drinking. And I've been thinking about it, and I don't want that to happen to somebody else. As hard as it is for me to not drink, I think it's more important that I mean, I have other children too that need me, and I'm living my life in a bottle instead of being a father. So.
Well, you understand, I really can't help you. You understand that, right?
Yes, sir.
I mean, whether I go along with what you want or not, I can't help you.
I know that, Your Honor.
So up until 4:10 yesterday, you just wanted to do the 9 months and get on with it, right?
No, I've been thinking about it since I originally was going to not do the pre-sentence report, because I thought it was hopeless and I was just going to go to prison anyway. I've been thinking about it since then. I left a message while my attorney was on vacation for a week for him to come and see me, and I guess he was been too busy to be able to do that, or I would have discussed it with him way before now. I finally got through to him on the phone yesterday, And I seriously did not have anybody come to see me from NeoCamp. There's another Jeremy Thomas in the jail, and I don't know if they went and got the wrong Jeremy Thomas to go see them, because they came and got me to see an attorney that wasn't mine, and it was for the other Jeremy Thomas. So I'm being honest with you when I say no one came and got me to see NeoCamp, or I would have went and at least seen them.
If I may, Your Honor, there is actually 2 Jeremy Thomases currently incarcerated, and there has been a mix-up when I've tried to meet with my client here.
All right, anything else you want to say?
No, sir, Your Honor.
Okay. Mr. Rhoda?
We would just need to adopt the recommendation, Judge, of 9 months in prison.
Okay. All right, I've reviewed the pre-sentence report and the drug and alcohol evaluation and the victim impact statement. I've listened to Mr. Thomas, Mr. Watson, Ms. Naroda. Considered all the factors in 29, 29, 11, 12, and 13. So like I said, Mr. Thomas, there's nothing I can do that's going to help you. Nothing I can do. I mean, you've been around the block many times. We're in the jail treatment program and successfully completed that, whatever that means. But you didn't implement whatever it is you may or may not have learned while you were there. When did you have your mental health evaluation?
I met with a psychologist that prescribed me medication, and they were scheduling a full assessment, but that I never got a chance to go to.
When were you evaluated? How long ago was that? While you were in jail this time right now?
No, I got evaluated when I did the jail treatment program, and then I followed up with Signature Health when I got out.
And what was that follow-up like? What'd you do?
I went and saw the psychologist that prescribed me Booze Bar and Abilify, and they scheduled.
Do you remember the psychologist's name?
No, sir, I don't.
Okay, go ahead.
And they scheduled a full assessment that I never got a chance to make it to.
Why didn't you make it?
Because of ending up in jail for the third OVI charge.
For this one?
The one before this one, Your Honor.
The one in Painesville Municipal?
Mm-hmm. Yes, sir.
So when's the last time you took any medication?
Probably like 2022 or 3.
So what exactly, you can't stop drinking. What other problems do you have besides that?
Cocaine, that's not really a drug that I abuse a lot. That's when I drink, sometimes I use it.
What about the mental health? How long have you had problems with that?
The anxiety I've had pretty much my whole life. But since I've turned 40, I hear voices, and that's why they gave me the Abilify, but they never diagnosed anything, and that's what the full assessment was supposed to do, is they were going to diagnose what exactly was causing it.
Where do you live?
With my mother and my stepfather here in Painesville.
All right, I'm going to place you on community control for 5 years. You're going to serve 90 days in jail with credit for 17. The last 30 days, you're going to be in the jail treatment program, complete it and follow the recommendations. And I guess completing it's the easy part. Paying attention and getting something out of it's the hard part. You figure out how you want to play it. Then you're going to go to NeoCap, you're going to get into that program, complete that program, and follow those recommendations. After that, you're going to go to either Concord Pines or Lake House, complete that program and follow recommendations. After you complete that, you're going to reside in a sober living facility for a minimum of 6 months. No drugs or alcohol with screens. You get a mental health evaluation and follow those recommendations, which means following up as they recommend. Going to go to at least 4 AA meetings a week and obtain a sponsor. You see only one doctor and one dentist and one pharmacist for medication. Take your medication as prescribed, sign releases for probation, and complete the decision points program and follow those recommendations and pay the cost and supervision fees associated with this case. Ms. Randallson, as to terms, anything else?
Your Honor, if he does the decision point in the jail, then it's going to kind of be like double dipping because it's going to do the one time.
He needs a double dip.
You want the double dip.
Twice as good.
Okay.
Okay. Do you understand the terms?
Yes, sir. Yeah.
Any question about the terms?
No, sir.
Okay. I can't help you. I can make stuff available to help you if you want to be helped. If you violate, then state will file a motion to terminate your community control, and if I find you violated, you face 30 months in prison. You understand that?
Yes, sir, Your Honor.
And then if that happens, when you get out, you might be on post-release control for up to 2 years under the parole authority with conditions. If you violate their conditions, they could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months of the time left under post-release control. There's a mandatory fine in the amount of $1,350. And I'm going to suspend your driver's license for a period of 4 years. And one further term that I neglected, additional term, is that at the appropriate time, you're going to get a valid driver's license. Anything else, Ms. Naroda?
Can I say something, Your Honor?
Yep.
When I spoke with the probation department, I specified that not going to neo camp to them, and I don't know if they didn't mention that or not, or.
No, they mentioned it. They mentioned it. You know why you don't think you need that? Oh, go ahead and say what you want. I mean, I'm not going to change my mind. Go ahead and say what you want. Now, if you want to, you can just go over there, refuse to get into the jail treatment program, and then we'll come back. Or you can complete it, and then you can refuse to go to neo camp, and then we'll come back. Or you can get your shit together and do what we're suggesting you do, so you don't keep ending up back here. But I don't care. Doesn't matter to me. It ain't my life. It's your life. Do whatever you want. Like I said, I can't help you. So you don't want to go to neo camp. Then if you don't want to go to neo camp, then when you're done over there, just refuse to go to neo camp, and we'll meet again. Or maybe you can try something different that will result in a different course for the next 25 years. But that's completely up to you. Ms. Naroda?
Was there a restitution, Mr. Hitchens?
Oh, yeah, $6,819.58. Anything else, Mr. Watson?
Nothing further, Your Honor.
All right, we're adjourned. You see, now wait a minute. Now, you understand something, Mr. Thomas, okay? They came in here working out a joint recommendation of 9 months in prison, okay? You didn't want that. You wanted treatment, okay? Now, you can talk to Mr. Watson, and he'll readily tell you that I really don't give a shit about joint recommendations, okay? I do what I think needs to be done under the circumstances, whether it's above the recommendation or below the recommendation, or if I think it's appropriate, the recommendation, okay? So I certainly don't care what you want, that you want to dictate to me the terms of what your probation is going to be, okay? Because I'll tell you as I sit here now, I think you blowing off NeoCap, okay, is gonna land you right back here at the next available opportunity, which ain't gonna be too long after you're free, okay? So I don't care what your recommendation is or what you want, okay? I'm doing what I think needs to be done, so you stop coming back here. But once again, do with it what you want.